When it comes to divorce, not all assets are created equal. And if you or your spouse own an airplane, or even partial interest in aviation businesses, hangars, or leases, you need a different kind of legal strategy. In this video, we are going to walk you through the best practices for handling aviation-related property during divorce. Whether you're the pilot or the spouse of one, this is for you. First, we need to talk about valuation. Planes aren't like cars or real estate. Their value depends on factors like the make and model, total airframe hours, maintenance history, upgrades, and market demand. That's why one of the first best practices is hiring a professional aircraft appraiser, someone FAA savvy, not just a general property expert. And don't forget associated items like logbooks, avionics packages, and ground equipment. These can significantly impact value and transferability. Second, understand how the aircraft is owned. Is it titled in one of your names? In an LLC? In a trust or partnership? Aviation assets are often held this way for tax or liability reasons, but from a divorce standpoint, it complicates things. You need to look beneath the FAA registration to see who actually paid for what, how it's used, and whether it's marital, non-marital, or a mix of both. Accurate tracing is crucial to protect your interest, or to prevent your spouse from overstating theirs. Third, we can't overlook hangar rights and airport leases. These aren't always physical property. Sometimes they're long-standing leaseholds or memberships in airport associations. They can be incredibly valuable and hard to replace, but they're also often restricted. Some can't be transferred or sold without consent from the airport authority. Knowing the terms of those agreements early is key to any reasonable settlement. Fourth, think about who actually uses the asset. In many cases, only one spouse is a licensed pilot. That means the other may not have a practical or safe way to benefit from keeping part ownership. In these situations, the most functional approach is often to award the asset to the pilot spouse and offset its value with other marital property. We work to structure those trades to be fair and tax efficient. Fifth, be prepared for the ongoing costs. Even if an aircraft sits idle, you've got insurance, maintenance, inspection, and hangar fees. If there's temporary possession of the plane during the divorce, we make sure those costs are accounted for and allocated. If one spouse is holding onto it for personal use, should the other share in footing the bill? Sixth, some aircraft are used for business, charter services, aerial surveying, or flight instruction. If your aviation interest is tied to income, that affects both the valuation of the asset and possibly your spousal maintenance obligations. We'll need to distinguish what's business income, what's personal use, and how to properly account for that in your financial disclosures. And finally, don't forget the tax side. Aircraft transactions can involve federal excise taxes, depreciation recapture, and IRS reporting issues, especially if the plane is in an LLC or tied to a business. We partner with aviation tax professionals to avoid costly surprises during or after settlement. Dividing aviation property in a divorce demands precision. At Atticus Family Law, we know how to handle high-value, high-complexity assets with the respect and strategy they require. If you're facing divorce and your family has aviation interests, we're here to help make your divorce success easy and your financial future secure. This is where things get better, guaranteed.